All right. Well, thank you everyone for the patience. Going back and forth, we're here thanks to the organizers R3D, R3D, sorry. And we have the speakers here, so we're going to start with Amos Taw. He's a legal advisor to the UN Special Rapporteur on Freedom of Expression, MMC from Google, and I'm just going to take the moderator's stance and take advantage of this by just saying that for us, this is a very important topic and a very important discussion, so I'm really attentive to this, but also just kind of leave you with a few questions in your mind on proportionality, the necessity to know, security and transparency as sort of 4 guiding principles for the discussion that I know the different speakers are going to talk about. So on to Amos.
Thank you so much, MC and Katiza, and to Luis as well for organizing this panel. I just wanted to maybe kind of briefly give a roundup of some of the standards promulgated within the UN system that might apply to very fast evolving surveillance technologies and surveillance operations around the world. And I mean, I think, and then I also want to kind of throw out challenges, right? And also ask questions in the hope that there will be both panel and audience participation so we can make this more interactive. So I think, you know, we recently briefed the special procedures, the freedom of expression mandate, as well as freedom of association and human rights defenders. We recently filed an amicus brief in a United States court case called Kidani versus Ethiopia, which basically concerns, I should start my timer just so I don't go over, which basically concerns activists being surveyed by the state of Ethiopia. In Maryland, this activist is an Ethiopian-American activist, and to cut to the chase, EFF is litigating this case. It's currently before appeal, and we basically laid out, you know, our positions on why this surveillance, this type of surveillance, this type of use of malware to infect another activist's computer extraterritorially actually violates the right to freedom of opinion and expression, the right to privacy, the right to freedom of association, and so on and so forth. So to give you some of the highlights, right, I think one of the most discussed norms that's taken on increasing importance in the digital age is the right to freedom of opinion, which is enshrined under Article 19.1 and is separate, you know, or separable rather, from Article 19.2. And the right to freedom of opinion is an absolute right and does not permit any interference. And now we see that in the digital age, the way we form and hold opinions are no longer confined to processing them in our own heads or writing them in a diary. We hold opinions on a Microsoft Word document. We hold opinions simply by browsing the internet and having the history of the websites being recorded somewhere. So to the extent that internet browsing histories, drafts of documents, digital memoranda that we don't share with anyone and therefore are not expressed, to the extent that these are mechanisms for opinion, is it ever legitimate or legal for governments to collect such information given the absolute nature of the Article 19.1 right? And I think then when we go more into communication surveillance, then we are talking more about Articles 19.2 and 19.3, and here I'm talking about the ICCPR, I'm sure many of you know, which, you know, and we go into the limitations criteria, of which there are 3, right? Provided by law, necessity, and proportionality. Just want to highlight maybe 1 or 2 things. That provided by law is not simply to, in our view, it's not simply for it to go through some formal legal process and you have legislation and therefore that makes it provided by law and satisfying the standard. I think law must also be reasonably clear and precise about the conditions under which surveillance may target each and every one of us. And I also think that under necessity and proportionality, we need to be clear that it implies that surveillance must not simply be reasonable, desirable, or even useful to accomplish a legitimate aim. There must be a more direct and immediate connection between the surveillance and the legitimate aim, whether national security or otherwise, that is sought to be pursued. Right, so I think there has been a greater development and strengthening of the human rights norms and criteria on digital surveillance, especially since the Snowden revelations in 2013. But at the same time, and I think this is where the challenge lies, is that surveillance operations and schemes around the world are also expanding in ways that raise extremely grave concerns for digital rights and digital expression. And so the challenge for us, I think, as a human rights community, as well as for governments, private actors, and international organizations, is how do we translate these norms? How do we translate these international norms into concrete and enforceable protections that governments respect? And so I have two questions here I want to throw out to the audience and the panelists. What can the UN system, whether the freedom of expression mandate, but also broader than the special procedures, the Human Rights Council, the General Assembly, any of the UN agencies, what can they do better or do more of in terms of supporting grassroots and local movements for more surveillance accountability? And the second question I want to ask, which is really related, is how do we develop and socialize standards that give concrete meaning to the criteria of necessity and proportionality? This may be a process question in the sense that we might ask for more transparency and more quality transparency from governments in the private sector. And we might also ask for judicial oversight. Again, I think we need model legislation. We need models for the kinds of oversight that we see. And I think the necessity and proportionality principles provide a really good template for that. And I also think it's an outcomes question, and this may be less talked about. There may be certain kinds of surveillance that are almost always never permissible under international human rights law. The most obvious example might be mass surveillance. And we also need to start trying to get meaningful perspectives on how to define or provide guidance on what are legitimate national security aims, because national security as a catch-all phrase for all kinds of surveillance is untenable, and we must start kind of really coming to a more well-defined definition, or at least, provide checks and balances that can limit the use of that term in the pursuit of surveillance regimes and operations. So I think that's really like kind of the remarks I had, and hopefully that those questions may be answered as we go along. Thank you so much.
Thank you. Moving on to the example in India, where I'm going to move to Arjun Jayakumar, Jayakumar, sorry. Thank you for correcting me. And he's a policy director at SFLC, and yeah, example of India.
Oh, yeah. Okay. There's something wrong with this mic, though. Hello. No, I think it's working now. It's working now. Okay, great. All right. So thank you for that introduction. So I am Arjun. I work with an organization called the Software Freedom Law Center. We are a non-profit organization that works to protect civil liberties in the digital space, and one of the main projects that we have worked on in the past is communication surveillance, and this is something that I was closely involved with drafting, so which is why I was looking forward to the session as much as anyone else here. So we had released a report called Communication Surveillance in India a couple of years ago, and what this report did was take a look at how communication surveillance is conducted in India, and more importantly, one of the chapters of this report was dedicated to evaluating the communication surveillance landscape in India against the 13 necessary and proportionate principles that we have just spoken about here. So again, the necessary and proportionate principles serve as an excellent frame of reference to evaluate the fairness of a communication surveillance regime in any jurisdiction. So I thought I would structure this by quickly going over a couple of these principles and seeing how the Indian surveillance landscape stacks up against these principles, as this would serve the dual purpose of evaluating the surveillance landscape itself and giving you a brief idea of how the whole thing works. So the first principle in the list of 13 principles is legality, which says that surveillance should always be carried out in accordance with law that has been clearly and very clearly laid out, and yeah, so that's the first principle. But we have determined in our reports that in India, this principle is not always observed very well, in the sense that we do have a set of laws that set out when communication surveillance can be undertaken, but these laws are anything but clear. for instance, the Telegraph Act and the Information Technology Act are the two main legislations that sanction communication surveillance in India. But the language of these sections are extremely broad and make room for the conduct of surveillance at basically any turn of the time. More importantly, in India, the citizens do not have a constitutional right to privacy. Some judicial interpretations by the Supreme Court have kind of interpreted a right to privacy as being implicit in the right to life and personal liberty under the Constitution, but this has also recently been up for debate. So the standing of the right to privacy in India is very, very questionable as of now. And moreover, there is also no periodic review of the laws that sanction and oversee surveillance, which means the legality principle is not very well met in India. Again, the principles of legitimate aim, necessity, adequacy, and proportionality, all of which I think are more or less related and state that surveillance must only be carried out in accordance with these principles when there is a legitimate aim, when it is strictly necessary to carry out surveillance, when you have exhausted all other means of procuring this said information. So none of this is seen to be observed in India again, because the reasons for which surveillance is usually permitted to be carried out range from everything from the very broad ambit of protection of national security right down to preventing the spread of computer viruses. And there are standing mandates within these provisions of laws to exhaust all other means of procuring this information, but this is not always seen to be done. Which is demonstrated by the fact that one of the requests that we had once placed before the government under the Right to Information Act about how often communication surveillance is actually carried out in India had revealed that on an average, every month, about 9,000 orders for surveillance are issued by one particular authority in the central government, which means that there is absolutely no scope for application of mind, and there is no scope for weighing these instances against the benefits and the costs and coming to an informed sort of a conclusion on whether or not this is a situation that warrants surveillance to begin with. Then moreover, surveillance in India is not carried out under the supervision of any sort of judicial oversight. So the entire surveillance process, starting with the sanctioning of the surveillance order, right down to the conduct of the surveillance itself, and the review of a surveillance order, everything is carried out by the executive arm of the government, and there is no intervention by any other arm of the government at any point, which means that it is entirely a monopolistic sort of a situation where there is a lot of opportunity for abuse of the process. There is, again, no user notification, as nobody is notified when surveillance is initiated or concluded, regardless of whether or not notifying people of this would, in fact, take away from the surveillance process altogether. And there is no transparency whatsoever when it comes to the surveillance landscape in India. As I said, any request to provide information on how communication surveillance is carried out is usually met with a response to the effect that this is a matter that relates to national security and which cannot be discussed as easily as people seem to think. So usually the norm is information denial, and we have to rely on reports in newspapers and information leaks to get even a brief idea of how the whole thing works in India. So as regards, so that's just some of the more important principles that I think from the list of 13 that I've already covered. And to not take up too much time, I'm just going to conclude here and probably participate in this as the discussion carries on. Thank you.
Thank you. We're going to move to Peter Kempian from the Council of Europe and Data Protection Unit.
Thank you very much. Thank you for the organizers for having me. In my intervention, I just would like to invite you to have a brief look into the interpretation of and the set of requirements the European Court of Human Rights established regarding surveillance and surveillance measures. But for beginning, it has to be said that surveillance is basically left to the discretion of national sovereign states. But however, it is widely recognized, and I will, of course, point it out in the court jurisprudence as well, that the use of surveillance measures represents an interference to Article 8 of the European Convention on Human Rights, as well as to Article 12 of the Universal Declaration on Human Rights as well, but now in my intervention I will focus on European legislation. So, and it has to be in accordance with law, but the surveillance measures are basically used for a very specific purpose, which is of public interest. And here I would like to invite you to really make the difference and to understand the difference the European Court is making between interest and rights. Because human rights are embedded in those declarations I was referring to, but the interests are set by the states. And public interest is only, and the use of surveillance measures can only be legitimate if they are respecting human rights. So with this introduction, I just would like to have a more detailed look at the court jurisprudence on this measure. So as I mentioned, there's a measure of discretion when evaluating threats to national security left to the states, and we're deciding how to combat these. But nevertheless, the court in its jurisprudence, which is very extensive, and it starts from the case called Klaas and others, and ends towards Zakharov and the Sabo case, which I'm not going to cite and not going into details here, but I invite you to read those. So the court in these cases established a threefold set of requirements where the member states have to respect when applying those measures. And a threefold set of requirements consist of the obligation that the measures have to be foreseen by law, has to be necessary in a democratic society, and an independent and an effective supervision has to be in place regarding towards this measure. And I would like to stop at the requirements number 2, because this requirements number 2 has some sub-requirements or elements which has to be taken care of. The necessary in a democratic society for the Court of Human Rights means that the measure has to be foreseen by the law, and it has to pursue a legitimate interest and has to be necessary and proportionate with a view to the legitimate aim pursued. So we are now in a situation where the state's margin for appreciation is no longer uniformly broad. For example, in a case law, there is so there is a reference to Article 3 of the European Convention that which speaks about torture, inhuman or degrading treatment, as well as punishment, and there is no margin of appreciation whatsoever. It goes on the same direction, but a little bit restrictive regarding Article 6 as well, where the court stated that if it exists a less intrusive measure available, so the use of surveillance measure cannot be legitimate, or can it be considered legitimate anymore? And it has also established a very well detailed requirements for independent court supervision. About secret surveillance, the court is relatively flexible on the subject of recognition of victim status. So it's quite open on receiving claims regarding the use of this measure, and the criteria of the accordance with law has to be understood that the law should be accessible and foreseeable and relatively detailed. There is also an obligation when it comes to the use of this measure to impose safeguards which must be accompanied, which must accompany the surveillance measures. And there is also the fourth criteria, which is the necessity criteria regarding the secret surveillance, where the court usually make a balance of the national security interest and the intrusion to the private life of the data subject. And usually it requires that guarantees against abuse have to be in place as well as supervision, as I mentioned before. So basically these are the requirements the European Court established, and I will be open for questions or clarification on this.
Thank you. And we're moving on to Katitza Rodriguez from EFF.
Thank you. Before explaining, we have been working for over a year on a comparative analysis of surveillance laws in 12 countries in Latin America. But before starting my presentation, I think it's important to remember a little about the history in Latin America and reflect on the horrific consequence of unchecked surveillance. And just to illustrate the case, in December 1992, following a sketch of a map given him by a whistleblower, a Paraguayan lawyer, Martin Almeida, drove to a secure police station near Asunción, Paraguay. Behind the police officers, in a rundown office building, he discovered a cache of 700,000 documents piled near to the ceiling. This was called the Terror Archive, an almost complete record of the interrogations, torture, and surveillance conducted by the Paraguayan military dictatorship of Stroessner. The files report details of Operation Condor, a clandestine program between the military dictatorships in Argentina, Brazil, Chile, Paraguay, Bolivia, Uruguay, between the 70s and the 80s. The military government of those nations agreed to cooperate in sending teams in other countries to track, monitor, and kill their political opponents. Stroessner's secret police used informants, telephotos, cameras, and wiretaps to build a paper database of everyone that was viewed as a threat, plus their friends and associates. The terror of archives show how far a country government might sink when unchecked by judicial authorities, public oversight bodies, and the knowledge of the general public. That was a quarter of a century ago. A modern Operation Condor would have more powerful tools at hand than just paper files, cameras, or wiretap phones. Today, digital surveillance technology leaves these techniques documented in the terror of archives in the dust. To help, so one way to stop these powers from being tuned against the public is to create robust and detailed modern electronic privacy laws to constrain its use that includes strong legal safeguards. We also need judges who are impartial and independent, knowledgeable on the topic, and a public oversight mechanism that allow the general public to know what their country's most secretive government agents are up to in their name. To assist in this task and help policymakers, IGF has been working for over a year with our partner organizations in 12 countries in Latin America to release a comparative legal analysis of surveillance laws in those countries. Our work, or our goal, was to shed a light on the current state of surveillance in the region, both in law and in practice. I don't know if we can show the page in the screen. Okay, I will continue. So what we have learned from this research, and I will be very briefly, it's really 100 pages, you can read it, there's a good summary too, but because we analyze all these laws against international human rights standards, and we take the necessary and proportionate principles as a benchmark, as a guidelines to assess compliance of each of these laws against international standards. So in the legality principle, we found in our research that many states only specifically authorize wiretapping, which means listening to or recording telephone conversations, and do not have precise legal authorizations to conduct new forms of surveillance, even in many countries with a few exceptions, for geolocation tracking, or even cell tower monitoring, using easy catchers or malware. Like wiretapping, these technologies are invasive and surreptitious, but also raise far different privacy concerns and legal questions that might be tackled. Just to put an example, in Colombia, you don't have prior judicial authorization to authorize any kind of wiretapping. Are we going to keep these same legal safeguards in that country for the use of technology that is even more invasive than just a simple wiretapping? It's a question. Despite the lack of legal footing, there appears to be widespread use of these technologies. A research by Derechos Digitales show that in the majority of Latin American countries, there were companies who were in touch or have purchased malicious software. In other countries, there is a legal framework that are written in a very broad way and might be interpreted as authorizing a wide range of existing surveillance and future surveillance. For instance, just to cite an example, Article 200 of the Criminal Procedural Code of Paraguay establishes that a judge can order the interception of communications of any accused person regardless of the technical means used to achieve it, which means that whatever technical means they were able to use will be authorized by this provision. This takes out the debate in Congress about the use of the right legal safeguards when you are using new surveillance technologies, or whether you should use it at all, or you should actually authorize at all this kind of new law enforcement powers. There are more examples, but I will give up to the second topic, which is the cultural secrecy. We found a very strong cultural secrecy in Latin America. Many states don't publish information about the purchase that they have about surveillance technology. States are not complying with freedom of information law when faced with requests for records regarding their surveillance laws and capabilities. States can issue transparency reports in order to provide useful information to citizens and users, but that is not happening. Sometimes you cannot, any general public cannot access it unless you ask for requested via freedom of information law. Telecommunications companies are not publishing nor either transparency reports or law enforcement guidelines to know which are the processes that the police have to follow when they knock at their door requesting users' data. So we really need to stop the culture of secrecy here, and we need to understand which are the capabilities. And this is obligation from the states. We cannot rely on whistleblowers to do it, but of course, whistleblowers have been fulfilling that role, but we haven't had our Snowden in Latin America yet. Another topic I want to talk briefly in 1 minute is public oversight. This is a really problematic area in Latin America because most of the oversight mechanisms were born in an era of, it came from a dictatorship culture when the culture of secrecy is very embedded in the system. Public oversight mechanisms have been weak, including legislative mechanisms. We have seen concrete examples in Guatemala, in Colombia, Peru, and Argentina of illegal surveillance targeting judges, politicians, opponent activists for illegal surveillance. So what we need and what we are trying to do is to have more public oversight, reports that the public can audit and not just relying on the traditional legislative oversight mechanisms that haven't worked in the region. Finally, and just to conclude, there are many other things that we need to improve, but we hope that necessary and proportionate principles, and in the website you can see, if you can navigate a little bit, this is the research we have in the table. You can see the country reports. There are 4 more reports that are coming from Central America, and if you can go back, yeah, and there are all the authors from all the organizations who work on this research, and we have also a map you can show. And you can click in each Mexico, and you can see what is happening in each of the country and the major fundings. So please visit necessaryandproportionate.org, and you will learn more what's going on in Latin America in surveillance.
Thank you so much to the panelists. So I think we'll start with questions. I know that Luis Fernando, the organizer, wanted to have an intervention, and then we'll take questions from all of you.
Thank you. I just want to make some comments regarding the very interesting participations that happened before me, and just want to tell you a tale about why these principles are important, because we talk about them and they seem very ethereal and they don't seem very real. And in particular, for example, in 2014 in Mexico, there was a telecommunications law passed that was particularly vague on certain aspects. It was vague on who could do surveillance. It was vague on whether you needed a judicial authorization to access metadata. And the effects of what happened have been documented. Is very important to look at. We were saying, because these provisions are vague, well, what is going to happen is that there's going to be a lot of authorities that don't have legal powers to do surveillance that are going to say, I have legal powers. And that's exactly what happened. In a report that we published last week that is called The State of Surveillance Out of Control, which is right now only available in Spanish, but it will be soon available in English. And I invite you to keep track on us. I'm Luis Fernando Garcia, director of R3D, Digital Rights Defense Network from Mexico. And what we did is that we did a lot of access to information requests, more than 600 of them. And we had to do 200 transparency appeals, and it was a big effort to really know what were the effects of this law. And what we found is that, for example, there was, when this new telecommunications law entered into effect, the number of authorities that asked for user data spiked, more than doubled. And the number of requests for user data also did. But another issue that is very important is the fact of the judicial authorization. Because it's useless to have very clear laws if there's no one to check whether those laws are being complied with. And what we found with the access to information requests was that, in effect, as we suspected, there were a lot of authorities that do not have legal powers to do surveillance that ask for telecommunication companies for access to user data. That 99% of all access to user data happened without judicial warrant, something that the Supreme Court of Mexico, we made a lawsuit against the telecommunications law, and in the process of doing the litigation inside of a Mexican constitutional system, this is what was happening. Authorities without authorization were asking for data without judicial warrant, and they were getting it. For example, the biggest mobile telecommunication company that, for example, in the first semester of this year, received more than 25,000 requests for user data. They never, ever, ever rejected one request. Any authority without even judicial warrant asked for data, they got it. And these are the effects of having unclear legislation with regard to who can make surveillance, on regard to whether you need a judicial warrant. Now, thanks to the litigation that we carried out, the Supreme Court established very clearly who can make surveillance, that you always need a warrant, except with an emergency system that has been established in law. But in the meantime, all this illegal, unwarranted, uncontrolled surveillance happened. And regarding transparency, which was also mentioned, I think it's important that we have meaningful transparency, because to have this number of how many requests doesn't really tell you much. And what we've been fighting for is to not only get the number of how many requests an authority makes and gets authorized, but how many people or devices are surveilled with those authorizations, because the number is totally different. And we actually got information from some authorities, and we confirmed this. For example, the Federal Police of Mexico between 2013 and 2015 got the authorization of a little over 200 requests for user data, or for the intervention of private communications, the intercept of private communications, and they, with those 200 authorizations, they were able to surveil 1,700 people. So it's important to have more meaningful statistics and data that can really serve this, the society and the population as a real means of exercising control over these authorities, not just random data, for example, that you can find in some companies' transparency reports that really doesn't tell you much about what's going on. Actually, this Monday, we also were successful in making the Supreme Court of Mexico order the National Security Agency here in Mexico to actually give us the number of how many people they surveilled in 2014, because they didn't want to give it, because they say that it harms national security, that the number of people, I didn't ask who, I just asked the number, but they said that it harmed national security. And now this precedent that we achieved in the Supreme Court, I think it's going to be useful, and it can be also an example about what real transparency really means. And by which numbers are important for transparency, I just want to add another point of data, which is we asked, because we get sold on these surveillance provisions as useful, that they are needed for law enforcement, and then certainly in certain occasions when they are used correctly, they certainly can be very useful for law enforcement. However, what we documented here in Mexico is that of all the prosecutors and all the investigations where there was a use of a surveillance technique, only a little bit over 8% of all those investigations became an accusation. There was the investigation became a formal accusation of a person, which means that at least, or moreover, 90% of the people that were surveilled in the context of a criminal investigation were never charged of any unlawful actions. So we were able to make this statistical analysis thanks to the information that we got through transparency. And it's important that we can get these. We didn't get this information from all prosecutors, from some. And it's important that these transparency provisions allow us as a society to make this kind of assessments. And finally, I just want to mention something that Amos was mentioning about certain types of surveillance that shouldn't be considered legitimate or proportionate and necessary to achieve even a very legitimate aim, which is, of course, mass surveillance. But I just want to mention two more. Data retention mandates, which is very important because from the litigation that we carried out against the telecommunications law before the Supreme Court of Mexico, even though we got some good provisions like this clarity about who can do surveillance and with which process and with judicial authorization, the bad part of that judgment was that the Supreme Court of Mexico validated the constitutionality of data retention, in contrary to what the European Court of Justice has already ruled, that these mandatory data retention mandates for telecommunication companies are disproportionate and unnecessary. We will, in the next day, in a few days, we will present a case to the Inter-American Commission on Human Rights regarding this issue, and we believe this is a very good opportunity for the Inter-American system of human rights to develop a more robust jurisprudence on surveillance, because we actually, the only piece of jurisprudence that has come out of the Inter-American system that is related to surveillance is the case of Escher versus Brazil. That was actually, we mentioned it in the lawsuit before the Supreme Court. The Supreme Court mentioned it in its judgment and said that it didn't apply to retention. It only applied to access to metadata. So it's a very good opportunity for the Inter-American system to develop a precedent that can help all the region. And finally, another measure that we believe is very problematic is the use of malware for surveillance, because even when traditional surveillance that requires the cooperation of a company in Mexico, it's really has not been very successful as a control, because the biggest company just gives the data without asking any questions, and because some authorities don't even think they need a warrant. The malware makes it even more difficult to exercise control over these surveillance techniques, because they don't need the collaboration of anyone. They can just do the surveillance directly. And we think this is very problematic, and as a general rule, it should be considered an unlawful and illegitimate way to do surveillance. It could only be used if it's regulated specifically with special safeguards in very extreme situations in which the traditional surveillance techniques wouldn't be useful or successful. We believe this is very important, especially in a country like Mexico, in which many times law enforcement and organized crime are the same thing. We need very strong safeguards, and don't give these authorities these string powers. Thank you.
Great, because we don't have that much time, though we can stay in the room if you all have time, but how about we take 2 or 3 questions and then distribute them to the panelists? So, all right, we can start with you.
This working? Okay. So hello, my name is Victor. I'm from the IGF Youth Program of Brazil and part of the Nucleus of Studies in Technology and Society at the University of São Paulo. My question is about accountability. As the digital surveillance issue is very connected with the national security issue, in most of the time, the struggle to access government information is obstructed by the justification that if this goes public, the country and the nation will be in danger. At the same time, transparency in these cases seems not enough, as the digital tool to intercept the communications can easily be hidden by the agencies that do that. With that said, how can we evaluate the accountability in these questions? And are we going to need one Snowden for each country? And thank you.
Thanks. Any further questions? Sure.
Steve Zeltzer, LaborNet APC, San Francisco. A concern that we have is the information that's being gathered by major tech companies like Google and Facebook, privacy of this information, and the use of this information by not only these companies, but by government agencies, and what rights do individuals have, working people have, that the information that they put up is not going to be used against them and used in retaliation, particularly workers who speak out about injustice on the job or health and safety on the job.
All right. Any questions from remote participants right now? No? One more, over here.
Yeah, Thomas Fitschen from the German Federal Foreign Office. I just wanted to pick up the question of proportionality, necessity, and also maybe give a reply to what you have just asked about accountability. The General Assembly resolution that is being run by Brazil and Germany for quite some time centers around unlawful and arbitrary surveillance, mass surveillance, and all of that. So that is a term that was taken, of course, from the International Covenant on Civil and Political Rights. So it's about 50 years old. Now you may ask, why did we stick to unlawful and arbitrary and didn't go into necessary and legitimate and proportionate in all of this? And why do we stick to this old language? The answer is, of course, when the resolution, and we were criticized for doing that. The answer is when the resolution was first introduced in 2014, please note the timing, the decision on the part of the co-sponsors of that resolution was we rather go for a consensus resolution rather than having something that is highly controversial, is being voted upon, and then divides the international community. So after long negotiations, the result was we have to stick to the language from the pact, because many states said, look, this is what we accepted by law. We signed up to the treaty that is binding. We are not ready to go in a resolution that is not binding beyond our legal obligations. That's why this unlawful and arbitrary turns up again. But in the latest resolution that is just about to be adopted in the General Assembly this December, we have introduced a new provision that says it calls upon states to develop or maintain and implement adequate legislation with effective sanctions and remedies that protects individuals against violations and abuses of the right to privacy, namely through unlawful and arbitrary collection, processing, retention, etc., by individuals, governments, business enterprises, and private organizations. So we still have the terminology, but the addressees have been enlarged quite a lot. So, thank you.
Thank you. Any of the panelists want to respond? I think Amos wanted to respond to him.
Yeah, I think that point is very well taken, on the distinction between arbitrary and unlawful and necessary and necessity and proportionality. I think my comments on necessity and proportionality are made in the context of Article 19 and the right to freedom of expression and the limitations clause that is made and established under Article 19.3. To the extent that we think that surveillance measures or regard surveillance measures as restrictions on freedom of expression, then surveillance measures should be analyzed under the limitations clause provided under Article 19.3, and that's how necessity and proportionality kick in. So just wanted to make that clarification. Thank you.
Further, Peter?
Debating, and there is also political debate also in that one. Of course, I don't want to go into very much into details on that. So, what would be the best of the solutions? And the court, in the court decisions I was referring to, there are no clear-cut answer either. However, being said that, there are some possibilities under the structure of checks and balances within a democratic society, whereas institutions can be set up and empowered for the oversight of these kind of activities. For example, in Europe, it is now very much in the center of debate to give this power to the data protection authorities. And I know Mexico has one. Latin America states are also in the phase of considering to establishing data protection authority. But as I said, there is no clear-cut answer in European jurisdiction, but there is a very stringent requirement that oversight has to be put in place, and it has to be independent and effective. And I can continue for hours on these two issues, but I think the institutional oversight is very important, as well as the public control of those institutions.
The issue is that after the Snowden revelation, there is a lack of trust about how governments around the world are using surveillance technology. And many of the reports that are being discussed within the oversight mechanism, whether it's within the Data Protection Authority or whether it's a legislative oversight mechanism, are not working. We lost trust. We don't have access. The public cannot know what they are doing. And so we need mechanisms which allows certain discretion. Some things might remain secret, but some others, the public needs to know. And that's we are calling for public oversight mechanisms. There is not necessarily the secretive legislative reports that are being written by the intelligence agencies to the member of parliaments without us knowing what's going on there. Just want to say that.
Any other questions in the back or other comments that you want to bring up?
Just a brief comment about accountability. The measures, I mentioned already meaningful transparency, not just any transparency, but meaningful transparency. But also with regard to it's not only necessary that a data protection authority exists, but that it has specific powers regarding surveillance. For example, the ability to do a random access to certain investigations, no, not to all of them, but a random sample of investigations in which it can get access to confidential information in order to be able to make an assessment on whether these provisions are being used correctly or not, and other types of specific powers. That's, I believe, what's been going on in Mexico. Data Protection Authority exists, but it hasn't really got into these kind of issues because it doesn't feel like it has these powers, specific powers. And also the right to notification is something that is very important to push for. It's important, I think the basic principle should be that any authority that uses a surveillance measure needs to know that eventually it will be known that they did this surveillance measure, and they will be scrutinized by an independent body, the judge for sure, an independent body hopefully, and also the person surveilled at one moment. This is, I think, something that needs to be guaranteed. But also, I will just second what Katitza said. I think we need to have a discussion on whether, I mean, if authorities really want these powers to invade privacy, they need to give out a little bit of, they have to have a little transparency with regard to methods as well. Many of the methods that they are using are not being revealed, and it's being used, this argument that they cannot reveal them because then you can circumvent. But I mean, at some point that you need to give up certain restrictions in order for society to really assess and discuss in a democratic way whether these methods are proportionate and necessary, which I understand necessary and proportionate as a synonym of arbitrary, but maybe I'm incorrect. So well, yeah, basically that. Thank you.
Yeah, I want to call attention to this notification principle because it's important for litigation and to be able to notify users of surveillance method so they can challenge the request. Obviously, it doesn't have to be in an ongoing investigation or when they put in jeopardy the investigation. But there are many cases that it's not. And the judge needs to assess whether that notification will put or not in jeopardy the investigation. And we need that so we can actually request a lawyer and the victim, the subject of surveillance, and challenge the request whether it's proportionate or not. And we have a case in the United States that my organization litigate. It was a case against Birgitta Bjornstein, an Icelandic parliamentarian who was part of the WikiLeaks investigation. And the US government notified Twitter with a gag order that does not allow Twitter to notify Birgitta that the requests have been made by the US government. Twitter, in that case, challenged the gag order, and then won in court. And that's why Birgitta was able to actually go to EFF, and we are able to, and ACLU, and we were able to provide counsel in the case and request that request was disproportionate. So that's a really principle that we would like to see more being recognized at the international level. We need it for litigation. Without that, it's very hard.
Thank you very much for joining the session, and good luck.